Law 1. This presentation is for the benefit of those young teachers who aspire to take up teaching of family law and further like to excel in the field of family law. Family law is one of the subjects which has gained a very lot of importance in the life of a person, and it touches each aspect of one's life. India is a land of diversities and it has a secular feature, and each person has a right to profess his or her own religion. Hence, there is a matter of personal relationship like marriage and divorce, which needs to be addressed time and again. Each person is governed by his or her personal law in respect to marriage, divorce, adoption, and succession. The teaching of the subject, family law, will cover a number of areas like personal laws like Hindu law, Muslim law, Christian, Parsis and Jews. There is a separate customary law which is there to address those people who are governed by their own customs and communities, and there are different tribes which are governed by the customary law. So family law as a whole, if you look at it, it covers various religions, which since India is a secular country, it covers those religions like Hindu, Muslim, Christian, Parsis and Jews. And the customary law applies to those communities which have their own set of customs, and they are governed by those customs irrespective of any religion. For the teaching of the subject, you can adopt various modes like PowerPoint presentations or lecture mode. And further, you can lay stress on the bare acts and latest case laws. It is advised that one should take a PowerPoint presentation and one should make a few bullet points. But it would be more advisable if you take the blend of the both. In case you adopt the PowerPoint presentation, you should try to explain the bullet points in a proper manner. Law is all about statutes. The core basis of a legal system rests on the laws, and they are in the form of bare acts. So I suggest that bare acts should be read properly to the students and with the students. You should make sure that on the smart boards, if you have, you display the bare acts and properly implement, properly interpret the statutes in front of the students. Each article or section in respect to various acts needs to be discussed properly with relevant case laws wherever required and latest case laws. Coming back to the subject of family law can be divided into two parts, codified and uncodified. Codified law which is written, whereas uncodified law which is not written, and it is there with the system from the ancient time, and we have carried it along with our system, but we have incorporated it in the books. Dealing with the subject of the family law, we need to discuss various religions on which this law is applicable. Firstly, you should explain to the students the application of the family law, like who are Hindus, who are Muslims, Christians, Parsis and Jews. So which law would be applicable to whom? Further, you need to explain the philosophy, social structure and concept relating to the legal system. Then comes the most important part, that is the sources of Hindu law, Muslim law, Christian and Parsi and Jews. This should be discussed properly because each religion has its own source of laws. Both ancient sources as well as modern sources should be referred. Further, you should take up the schools of Hindu law, Muslim law and Christian, Parsis and Jews. Here you should make a mention of the migration and domicile rules relating to certain communities. Since with the concept of globalization, people are migrating to other countries, and with them they carry their personal laws. When they carry their personal laws, they carry with them all the personal laws relating to them in respect to their religion. So there is a bit of conflict of laws here, which you also need to address while you discuss the introductory part of family law, because each person who is governed by a particular religion which will carry his or her personal law along with it, and in case there is a dispute in respect to marriage, divorce, succession or adoption, that conflict of law will arise, that by which law he will be governed, whether he will be governed by the law of that country in which he has migrated, or whether he will be governed by those laws from law of that country from which he has come. So here the introductory part of family law comes to an end. You introduce the subject and you tell the students how and what rules are applicable to whom. Coming next to the concept of marriage. Now further you should explain in detail the importance of marriage. Under Hindu law, it is a sacrament. We understand that, whereas in Muslim law, it is a contract. Under Hindu law, it is a sacrament, but after the passing of the Hindu Marriage Act 1955, we even have a concept of divorce. Earlier, divorce was not available under the Hindu law, but after 1955 Act, there is a provision of taking a divorce from the husband or vice versa from the wife. You need to explain the right to marry. We all know the right has been recognized. No person, under Article 21 of the Constitution of India, which says that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right has been recognized even under the Universal Declaration of Human Rights 1948. Article 16 of the same states, men and women of full age without any limitation due to race, nationality or religion have the right to marry and found a family. They are entitled to equal rights as to marriage, during marriage and its dissolution. Marriage shall be entered into only with the free and full consent of intending spouses. The family is the natural and fundamental group unit of the society, and it is entitled to protection by society and the state. Further, when we talk of marriage, each religion has its own personal law in respect to marriage. Under Hindu law, while you go further explaining the concept of marriage, conditions relating to a valid marriage should be discussed. They are different in Hindu law, Muslim law, Parsi, Christian and Jews. And in the end, I would like to mention here that in India, we have the Special Marriage Act of 1954, which is actually 1954, under which we have a provision which is irrespective of under which the requisites of a valid marriage are much different from the marriage under personal laws. Section 4 of the Hindu Marriage Act, Section 4 of the Special Marriage Act 1954 lays down conditions for solemnization of special marriages. It says that a marriage between two persons may be solemnized under the Act if at the time of marriage the following conditions are fulfilled. Firstly, neither party has a spouse living. Secondly, neither party is incapable of giving a valid consent to it in consequences of unsoundness of mind. Thirdly, though it is capable of giving a valid consent, it has been suffering from mental disorder of such a kind or such an extent as to be unfit for marriage and procreation of children. And lastly, it has been subject to recurrent attack of insanity. It is significant to note that the Special Marriage Act cuts across all the barriers of caste, creed, community and religion and permits any two persons to marry under the provisions of this Act without letting them change their religion or affiliations. We have number of cases in this context, and these cases should actually be referred to the students. When we talk of marriage, another aspect which is very important is registration of marriage. Even under the personal laws, it has been seen that there are a number of frauds which are committed at the time of marriage or after marriage. It comes to the notice of the parties that there has been some issue, and there are denial of marriages also when the marriages are held in away from people in a very small gathering. So registration of marriage has gained a lot of importance. You need to discuss here the provisions of the special marriage of the Hindu law, Christian law, Parsi and the Jews, whereas the registration of marriage is made compulsory by the government now. In the case of Ashmani versus Seema, that case needs to be discussed here. Under the Muslim law, marriage is already registered since it is in the form of a nikah nama. So these are some of the things which we need to take care when it comes to the point of marriage. Then coming next to the conditions of a valid marriage. There are a number of conditions which are given under the Hindu law, under the Parsi, Christian and Special Marriage Act relating to validity of marriage. Muslims have their own concept since they are governed by the Shariat law, so the conditions of marriage are much different. You need to categorize that what are the essentials of a valid marriage under separate personal laws. Then comes the concept of void, voidable and irregular marriages. In case the marriage suffers from any kind of irregularity, or there is any in case there is any lacuna in the marriage will fall void. So conditions of void marriages have been given under different personal laws. Then there is another aspect, voidable marriage. There are certain marriages in which which are not void, but they may be voidable at the instance of both the parties. Those points also have to be enumerated. And as far as Muslim law is concerned, there are certain irregularities which have been given in the marriages, and after the removal of those irregularities, the marriage can be made valid. So rules relating to void, voidable or irregular marriages need to be very clearly given to the students, so that we do not give any kind of a false apprehension that a marriage which is voidable, it can be made valid, whereas if a marriage is void under any condition, it can never be made valid. So this thing has to be specifically mentioned here. Then the conditions, then we come to the matrimonial remedies. Under the matrimonial remedies, we have three. First is divorce, second is judicial separation, and third is restitution of conjugal rights. Let's take divorce first. Divorce under the Hindu law was never a concept before the Act of 1955, as I have told you earlier. There was unlimited polygamy, and there was no relief to any person who was married. They had to continue with the marriage itself. But later on, the grounds of divorce were made available to both the parties under Section 13. The major grounds of divorce are adultery, cruelty, desertion, conversion, fraud, bigamy, impotency, non-consummation of marriage, mental illness, abnormality, physical disease, leprosy, venereal disease, null resumption of cohabitation after decree or separation or restitution, pre-marriage pregnancy of wife. Now, each of these ground needs to be elaborated with relevant case laws and latest case laws, but there are certain authorities which have never been changed, so those authorities should also be referred. These should be elaborated to the students so that individual ground becomes known to the student how they can apply. There are a number of additional grounds which are available to the wife as far as divorce is concerned. Those grounds, there are 4 grounds which are available to the wife as far as divorce is concerned. Firstly, if the husband has already married and there are 2 wives, then the wife can take divorce from the husband with the consent that there is a first wife and she will not like to continue. Second, a wife can seek divorce also on the ground that since the solemnization of marriage of husband, uh, he has been guilty of rape or sodomy or bestiality. Thirdly, non-resumption of cohabitation for a period of 1 year or more after passing of the decree of maintenance under Section 18 of the Hindu Adoption and Marriage Act or under Section 125 of the Criminal Code of Procedure if there has been non-maintenance by the husband. The fourth ground is also available to the wife where she can repudiate her marriage if she was married before the age of 18 years, but after she has attained the age of 15 years, she has to give her opinion. Child marriages were very much prevalent in India before the Hindu Marriage Act of 1955, and a lot of girls were married before the age of 18 years. Now, in those cases, if there is availability of choice to the wife, she has a right to repudiate her marriage after the age of 15 years, but before attaining the age of 18 years. So these are four grounds which are available to the wife at large. Now, coming up to, these are some of the grounds which are available to the wife at large. Now, there are certain grounds which are available to both the parties. Under Section 13B, the parties have a right to dissolve the marriage mutually. Divorce by mutual consent has been discussed under Section 28 of the Special Marriage Act 1954 and likewise under Section 13B of the Hindu Marriage Act of 1955. And there are extraneous considerations which can be taken there. Even if the marriage has been resisted, the mutual divorce can be taken by both the parties by reaching a conclusion where both the parties feel that they cannot continue further and they do not want to go into any further kind of litigation. Now, then we come to, apart from this, there is a legal position under Parsi, Christian and Muslim law also, whereas the divorce by mutual consent can also be taken. As far as Muslim law is concerned, it is governed by Muslim law. Divorce is governed by khula. There are under Muslim law, there are two kinds of divorces which you can take. First is under khula, second is under murabbat. So both these under both these divorces, the wife or the husband can take divorce. Whereas under Muslim law, triple talaq was authority, but very recently, and one of the judgments, the court has considered the law to be triple talaq to be unconstitutional, and apart from it, the act also has been passed as far as the triple talaq is concerned. If you look at the concept of marriage, there have been instances where both the parties in the modern times, with the concept of both the spouses working, we find that there have been cases where the parties have been residing separately for a very long time without interaction with each other. Basically, the concept of marriage is for company, for procreation of children, for attainment of social status, for protection, for certain amount of companionship. But if it is found that the marriage has reached such a state that any of these conditions has not been fulfilled or is not being fulfilled, it is seen that there is irretrievable breakdown of marriage. Now, in this case, divorce law of India, especially Hindu law, they are concerned, they have moved under exceptional circumstances to divorce. The court has taken cognizance in many cases in which it is seen that marriages have been solemnized and there have been 12 to 25 years of the parties being married, but they have not stayed together and they have been going through a lot of trauma, and the court gives in a decision that the marriage has actually irretrievably broken down, and this ground also has attained some kind of a recognition in the present time. Now, the step towards the recognition of principle of breakdown of marriage was actually introduced in the mutual divorces, whereas in this case, both the parties then agree that they would like to separate and their marriage has been broken down. So this is in respect to marriage. Further, there are certain grounds relating to matrimonial relief. When we talk of matrimonial relief, there are certain areas in which we find that the marriage could not have been solemnized if it suffers from certain, say, deficiencies, like you cannot get married within the Sapinda relationship. Apart from it, under the Muslim law also, the marriage falls void if it suffers from consanguinity, affinity, fosterage, and unlawful conjugation. Another aspect which you have is renunciation of the world by entering into another religion. Many a times, either of the spouses, he leaves the spouse and takes up to the religious spirituality. The other spouse is left behind. In such cases, this is another ground of matrimonial relief which needs to be entertained. Apart from it, if the respondent has not been heard of for the last 7 years, this is also considered to be a ground of divorce. Then, sentencing of imprisonment. If the person has been sentenced to more than 4 years of imprisonment, the either spouses has a choice to walk out of marriage. Then we come to the next topic, that is bars to matrimonial relief. After discussing marriage, divorce, irretrievable breakdown of marriage, mutual divorce, matrimonial relief, in the last, you need to discuss various bars to matrimonial relief. There are a number of bars to matrimonial relief, like firstly, taking advantage or wrong or disability. Secondly, collusion, condonation, delay, then 1 year bar of separation. So these bars of matrimonial relief you should discuss in detail. This is the first part of the lecture of the family law. Thank you.